Flashman.
Your Honor. Has characterized this as basically being a very simple matter and really essentially something that just ought to be rubber stamp approved because there's no reason to deny. There's no basis. Basically, by her analysis of what the committee did and the circumstances in which they did it, essentially the court has no power to not allow the validation. That whatever the committee did or didn't do, whatever evidence they did or didn't have before them, they had the absolute discretion to go ahead and approve the bonds, and the court must, again by her analysis, must go ahead and validate the committee's actions. We don't see the law that way. We think the reason why there is validation proceedings at all is because there's a recognition that it is possible for things to go wrong. It is possible for a bond issuance to be authorized when it shouldn't have been. And the whole point of the validation is to determine one way or the other whether that authorization was valid or not. We think there are a number of reasons why in this particular situation it wasn't valid. Probably the central reason is because this isn't the project that the voters approved, and that goes not to the uses of the bond funds, but to the purpose of the bond measure. And admittedly, those two kind of tend to overlap. That's why, of course, Your Honor first decided that these two cases, the Toss case and this case, were related, was because they are very closely related. Indeed, the Toss case initially had causes of action asking the courts to not allow the issuance of the bond. We agreed to take those out of the Toss case and deal with them here. But that doesn't mean, as Ms. Duke stated in her reply brief, that we waive those claims and that those claims can no longer be brought. Again, we've actually asked that portion of the reply brief be stricken because it is in fact inconsistent with the stipulation that was signed by the parties and approved by the court. What that stipulation essentially said was the Toss case is about the uses of bond funds. The validation case is about the issuance of those bonds and whether that issuance was proper. And one of the questions that's central, the question of whether issuance was proper, is are those bonds going to be used for the purpose that the bond measure specified? And again, that purpose is to build a high-speed rail system, a true high-speed rail system. And as Ms. Ross has explained, what the authority is building and what the evidence that's basically before the court in terms of, for example, the revised 2012 funding plan and the legislature's appropriation for building the initial construction segment, what that says is what they are building is not what the voters approved. What they are building is something that, and again, as Union Pacific pointed out, may well in fact forever be a blended system. Because the revised funding plan doesn't say that we are just looking at this as one phase that will eventually become a full high-speed rail system. The revised funding plan says it could become a true It could become a true high-speed rail system if that is necessary. And that if that is necessary is crucial because it says if it's not necessary, then it won't become a true high-speed rail system. It will stay a blended system. And that's inconsistent with the purpose of the bond measure. So that's, I think, a crucial point. And again, other issues that arise in terms of will the system that the authority is building be able to meet the requirements set forth in 2704.09. And if it can't meet those requirements, that's not something, under 2704.08, yes, the bond measure itself says, well, non-compliance with 2704.08 is not a reason to invalidate the bonds. But it didn't say that about 2704.09, which sets forth, this is what this measure is about, this is what the system has to be able to do. it's defining the purposes of the bond measure. And this system, as the authority has laid it out in the revised funding plan and as it's laid out in the appropriation that the legislature has granted, it doesn't meet those, and it won't meet those. So it's not being, the funds would be not being used for the purpose that the voters intended. Secondly, Ms. Zook has argued that essentially the committee had unfettered discretion to approve a bond without any evidence before it, without anything other than the authorities asking it to. And again, I go back to my question, well, if someone asks you for 25 cents, is the fact that they ask you, is that evidence to justify you giving them 25 cents? It's nothing more than a bare request. And if they said, can I have 25 cents for a cup of coffee, then maybe you have a justification to say, well, okay, they need a cup of coffee, I have 25 cents. They've given me a justification as a basis for saying, yes, I should do this. But they didn't do that. All they did is say, give us the money. And that's not sufficient under the very terms of the Bond Act itself that said they had to find that it was even necessary or desirable to authorize issuing bonds. And just saying, give us the money, doesn't show that it's necessary or desirable, just as they want. And I don't think you can go beyond that and say, well, because they asked for it, it must have been necessary or desirable. Otherwise, why put in the Bond Act the requirement that they determine that it's necessary, desirable, or not? The fact that they gave in the Bond Act the ability to say it's not necessarily or necessary, desirable, says just asking for the money, which is again a precondition for that determination, doesn't in itself satisfy that requirement. And they didn't have any evidence beyond that to satisfy the requirement. One other point, and this goes back to the state issue. The authorities have pointed to a February bond sale and say they need to be able to sell bonds for the purposes of subsection G and subsection H. Well, those two subsections together basically amount to about $900 million of bonds. And again, we pointed out that the authorities had already spent somewhere over $300 million of bond funds. And presumably most of that has already been spent on G and H. So they really aren't talking about spending $900 million of bond funds. They're really only talking about spending $600 million of bond funds. And yet they have much more than that available in federal funds that can be used to make any differences. And under the agreement, the ARA agreement between the authority and the federal government, they don't have to match at the exact same time the federal spending and the state spending. They can spend federal funds first and then later spend state funds to match it. So there's no urgency to say we've got to sell the bonds in February or we're going to run out of money. They've got $3 billion in federal funds that's available to them. They can spend until we find out what's going on with the preemption issue. And even if you were going to say, well, maybe they do need us to issue some bonds this coming February, even if you decided that really needs to happen, we're not talking $9 billion. We're talking $900 million, less than $900 million. And so the court, if the court is inclined to grant any validation right now, the court should only validate the amount of bonds that they need to issue in February. And beyond that, the court should wait because the bulk of the money is for construction. And the question of whether they can spend construction money under 2704.08D, that's crucial in terms of the question about CEQA compliance. If the court determines that, if the Court of Appeal determines that CEQA is preempted, and therefore they cannot fulfill the requirements of subsection C, then it becomes impossible for them to use the funds that are defined in subsection D. And therefore those bonds, that part of the bond measure essentially is voided because it's impossible. And therefore, that part of the bond measure should not be validated because it may not even be possible. It may be a void section of the bond measure.